Welcome to our comprehensive guide on the EB-2 National Interest Waiver series and welcome to episode 1. In this series, we will break down exactly how you can secure a US green card without employer sponsorship. Let's start with the foundation, understanding the history and the legal framework that makes this possible. Hi everyone, my name is Mahmudul Hasan. I am an attorney. I have been practicing immigration law in the United States for the last 7 years. So far, I have worked on almost all types of immigration classification. I have grown my expertise in employment-based immigration, investment immigration, and immigration litigation. Disclaimer: this content is provided for educational purposes only and does not establish an attorney-client relationship between you and me or anyone associated with this series. Immigration law is complex and every case requires careful evaluation based on individual circumstances. We strongly recommend consulting with an experienced immigration attorney before making any immigration-related decisions. Additionally, throughout this series, we will present case studies to illustrate key aspects of the petition process and regulatory criteria. These case studies are entirely fictional and are intended only for explanatory purposes. Imagine you are a scientist on the edge of a breakthrough, an entrepreneur with a world-changing vision, or an engineer shaping the future. You have dedicated years to your work, poured your passion into every idea, and you know that the United States is where your potential can truly soar. Just as you prepare to take the next step, you find yourself facing a maze of bureaucracy, a system that demands an employer sponsorship, an arduous labor certification process, and an uncertain wait that stretches endlessly into the future. What once felt like a clear journey now seems riddled with obstacles, each one threatening to slow you down or worse, stop you altogether. That's where the EB-2 National Interest Waiver (NIW) changes everything. No need for employer sponsorship, no burdensome labor certification. Only your achievements, your contributions, and your petition demonstrating that your work is too valuable to be constrained by bureaucracy. The EB-2 National Interest Waiver (NIW) is one of the most flexible and sought-after employment-based green card options, allowing skilled professionals, researchers, entrepreneurs, and innovators to obtain US permanent residency without the need for employer sponsorship. Over the past few years, the EB-2 NIW has gained increasing recognition as a preferred immigration pathway for individuals in critical fields such as STEM, science, technology, engineering, and mathematics, healthcare, cybersecurity, renewable energy, business innovation, public policy, entrepreneurship, etc. But how does it work? What does it take to qualify? And most importantly, how can you position yourself for success? In this video, we will break it all down, covering employment visa categories, legal history, eligibility criteria, benefits, and the future of the EB-2 NIW. If you are someone who wants to make a lasting impact, this could be your pathway to US permanent residency. EB-2 NIW is more than a visa, it's a recognition of your potential. To fully comprehend the significance of the EB-2 NIW category, it is crucial to first analyze the legal framework governing employment-based immigration in the United States. US immigration law categorizes work-related visas into two primary groups: non-immigrant visas and immigrant visas. Non-immigrant visas such as H-1B, L-1 or O-1 are temporary work visas that grant foreign nationals the legal authorization to work in the United States for a specified period. In contrast, immigrant visas such as EB-1, EB-2 or EB-3 provide lawful permanent residency, green card status, and a pathway to US citizenship. Under the traditional EB-2 green card process, applicants must obtain sponsorship from a US employer and complete the labor certification PERM process, which serves to confirm that no qualified US workers are available to fill the position in question. However, the EB-2 NIW offers an exception to these requirements. Unlike the standard EB-2 category, which mandates a job offer, employer sponsorship, and PERM certification, the EB-2 NIW permits individuals to self-petition by demonstrating that their work is of substantial benefit to the national interest of the United States. This waiver significantly enhances the flexibility of the EB-2 category, making it one of the most sought-after green card options particularly for professionals engaged in STEM and other sectors that contribute to economic growth and national advancement. As a result, the EB-2 NIW remains a highly advantageous pathway for qualified individuals seeking to establish permanent residency in the United States. History. In 1998, the United States sought to establish a clear legal standard for determining when a foreign professional's work justified a National Interest Waiver (NIW) under the EB-2 immigrant visa category. The ruling in matter of New York State Department of Transportation (NYS) set forth a three-pronged test requiring petitioners to demonstrate 1. Their work had national importance beyond a local or regional scope. 2. They possessed exceptional skills and a strong professional record. 3. Their contributions were so significant that the US government's interest in labor certification should be waived. However, while the ruling seemed reasonable in theory, in practice it became a hurdle, preventing countless exceptional professionals from bringing their expertise and innovation to the United States. For example, physicians working in medically underserved areas, entrepreneurs launching high-impact startups, and researchers engaged in cutting-edge fields often faced denials because they could not immediately prove nationwide impact, despite their clear contributions to US society and the economy. Nearly 2 decades after the matter of NYS ruling, the United States stood at the forefront of technological innovation, globalization, and an increasingly dynamic workforce. Then, in 2016, a landmark decision reshaped the landscape of employment-based immigration, matter of Dhanasar. At the center of this ruling was Mr. Dhanasar, an aerospace engineer whose research had the potential to drive significant advancements in science and technology. Committed to his field, Mr. Dhanasar sought to obtain an NIW to continue his work in the United States. However, a major obstacle stood in his way: the restrictive standards established in matter of NYS. Under these outdated rules, applicants had to prove that their work was of national scope, a requirement that made it exceedingly difficult for many researchers, scientists, and entrepreneurs like Mr. Dhanasar to qualify. Undeterred by these challenges, Mr. Dhanasar fought on. His case ultimately reached the Administrative Appeals Office (AAO), where officials took a critical look at the existing NIW framework. They recognized a fundamental flaw. Too many brilliant minds were being denied opportunities due to rigid technicalities. Realizing the need for change, the AAO overturned the restrictive NYS precedent and introduced a new, more flexible three-pronged test, one that acknowledged that national interest could no longer be confined to outdated definitions. This pivotal ruling in matter of Dhanasar not only redefined the NIW criteria but also opened doors for innovators, researchers, and professionals whose contributions would shape the future of the United States. For the first time, USCIS adopted a holistic approach to evaluating NIW petitions. 1. Substantial merit and national importance. The work must have economic, societal, technological, or scientific value, even if its impact is initially regional. 2. Well-positioned to advance the work. The applicant must demonstrate expertise, accomplishments, and resources to successfully further their field. 3. Balancing test. Waiving the job offer and labor certification must be beneficial to the US, especially in specialized or urgent fields. With the Dhanasar framework, a new era of opportunity began. The matter of Dhanasar ruling was more than a legal decision. It recognized that talent and innovation do not always begin on a national scale, but their ripple effects can change the world. As we are ending our discussion on the fundamentals of EB-2 NIW and the legal history of matter of Dhanasar, please follow all parts of our EB-2 NIW series for a complete understanding of an EB-2 NIW petition. If you have any questions, please leave that in the comment box. We will try to cover your questions in our subsequent discussions. Stay tuned for more immigration discussions. Follow us on Facebook, YouTube, and LinkedIn. Once again, please consult your immigration attorney before you make your immigration decision. Thank you for watching this.